Each new year brings a host of new laws that go into effect, and 2018 isn't any different, especially in our great state of California. Here are some of the hottest and new laws that we are going to discuss today. We witnessed the Me Too movement, which galvanized the country into determining what is appropriate and what isn't in terms of unwanted sexual advances. There are new rules on what to say and what not to say when interviewing a potential job applicant. That has changed the interviewing landscape completely. Another employment law topic we will discuss is the importance in accommodating employee requests in a correct manner. And finally, we will end by discussing the top 3 wage and hour complaints for the upcoming year. So let's get started. The first topic we'll cover today is harassment. As we've seen in the news this past year, harassment claims continue to increase. In California, harassment training requirements for supervisors has increased starting January 1, 2018, to include material on gender expression, gender identity, sexual orientation. These are just a few. The initial training requirements also include 2 hours of sexual harassment training for supervisors every 2 years. Employers must also include FEHA's posters on transgender rights to be fully compliant. Now, although these trainings are not required for small offices with less than 50 employees, it's still advised to provide training to help you keep your practice compliant against harassment claims. Now, in order to prevent harassment, you will need to ensure that your policy covers all the requirements under California's Fair Employment and Housing Council. Although this list is extensive, you will generally want to be sure that your investigations and complaints are confidential, that you clarify that there will be no form of retaliation for submitting a claim, and that harassment is not acceptable under any circumstances. Now, another big topic for 2018 involves interviewing employees. The first law I'd like to discuss is called Ban the Box. Under the Ban the Box provisions, employers with 5 or more employees are now prohibited from asking about a job applicant's criminal history until they've made an official conditional employment offer. Once a legal background check has been completed and the employer decides that the employee is not qualified for the position, the employer needs to then follow specific steps to ensure they are following the legal requirements correctly. Another protection that came into play this year is regarding salary inquiries. Beginning January 1st, California employers may not ask job applicants about their previous salary history, including compensation and benefits. This means that the typical question that you'd find on a standard employment application, "What is your current salary?" is no longer legal. Be sure that if you are obtaining this information, it's only because the employee is voluntarily providing it to you. Now, while interviewing a candidate, it is important not to ask certain questions that could be seen as discriminatory. Examples of these types of questions are, do you have children? How old are you? Are you religious? However, in order to be compliant, you need to change these to, are you able to meet the attendance requirements of this position? Are you over the age of 18? Or are you available on weekends? At the end of this video, I will give you instructions on how to receive a list of questions that you can ask during your interviews. Now, the California Fair Employment and Housing Act prohibits discrimination against the employees and applicants based on an extensive list of protected classes that we previously listed. So it's crucial to be sure you're staying as objective as possible in your interview questions. The third topic that is always a continual issue in employment claims is accommodations. It's important to keep in mind that if an employee submits an accommodation request, whether as to disability, religion, or gender identity and expression, you'll need to be sure that you are handling it correctly. There are only 2 circumstances in which you would not have to accommodate the employee. The first is if you would need to close the office as a result of the accommodation, because it's such a financial burden on the practice. Even if the accommodation would make the practice lose money, you'd have to go into bankruptcy the next day in order to meet this requirement. It's that drastic. Now, be sure that it's not just an inconvenience for the practice. The second would be if there is truly not a position in the office that can meet the employee's accommodations. Before coming to this conclusion, you'll want to be sure to discuss the employee's accommodations with them and what the position they think they'd be able to do in the office that would meet their accommodation. At this point, You've lowered the risk if you truly cannot accommodate the employee by discussing it with them first. Finally, I also want to go over the 3 types of claims that are anticipated to be prominent in 2018. The first is overtime claims and claims for incorrect sick pay. Because California has additional requirements than the federal law, employers need to be extra careful when it comes to paying overtime and providing compliant sick leave. Employers need to ensure that they are paying overtime for any time worked over 8 hours in a workday or 40 hours in a work week. California law requires that you also provide 24 hours of sick leave to your employees, with many cities and municipalities that have created their own complex requirements. You'll need to be sure that you're aware of the sick leave laws in your city or county to be sure you are following them correctly. The second issue that we expect to cause some problems for employers has to do with rest break claims. Specifically, if an employer has a policy that requires employees to stay on the premises during their rest breaks. In a seminal case in California Supreme Court, it was held that the rest break requirements obligate employers to allow employees to use their rest period as they wish, which includes the ability to leave the practice during this time. The third expected claim is fair pay claims. Under the California Equal Pay Act, all employees are protected from being paid less than another employee of the opposite sex for equal work. Effective last year, the act was extended to also include race and ethnicity as a protected category. It's also important to keep in mind that employees can file wage claims up to 3 years from the date of the violation, which means that they can collect wages for unpaid overtime and missed meal and rest breaks up to 3 years after they occur. This is why it's so important to remedy these payments as soon as possible to lower your potential costs if an employee files a claim down the road, or if you're getting ready for retirement. To sum up what we've just learned, it is imperative that you train your employees on how to prevent sexual harassment by ensuring your policies are covered by California's Fair Employment and Housing Council. Secondly, make sure your hiring policies are up to date so hiring managers are using their best practices when inquiring about an applicant's background. Third, it is best to exercise good judgment when accommodating employee requests. Now, going back to what I promised you earlier, to receive a list of questions you can ask during interviews, please text the words CALAW 2018 to the number 44222. Lastly, make sure you stay compliant with wage and hour claims as they are projected to increase in 2018. Thank you for tuning in, and best of luck to you as you stay compliant throughout this year.